3, go. Hello, sir. This is our presentation about Chapter 2, Courts and Alternative Dispute Resolution. And our presentation will be divided into 5 different parts, as you see in the table of contents here. And I will go right into the first part, which is the judiciary role in the American government. Firstly is the judicial review. Judicial reviews are a challenge to the way in which a decision has been made rather than the rights and wrongs of the conclusion reached. And the decision which often fall into the judicial review is the decision of regulatory bodies, decision relating to prisoner rights, etc. And the origins of the judicial review is from, it was established by the US Supreme Court in Marbury v. Madison in 1803. And that the Marbury v. Madison is the name of the court case. And the judicial review is exercised by both federal and the state. Let's move on to some basic judicial requirement. The definition of jurisdiction is the power or right or authority to interpret and apply the law. There are many categories in jurisdiction. I will go to the first is jurisdiction over person or property, and jurisdiction over person and property. Okay. And the jurisdiction over person, or aka the in personam jurisdiction, is the jurisdiction over any person or business involved in a legal action, and it is determined by the geographic area of the person or the business. For example, a person gets a ticket, and the local traffic can hear the case because law allow that court jurisdiction over traffic violation within the geographical boundaries. And if the person is ticketed in a different town, then a different court would have jurisdiction based on that territory. And the in rem jurisdiction or a defendant property, and it is determined by the geographic location of the property in dispute. And for example, if a divorcing couple asks a court to supervise sale of their family home, the court exercises in rem jurisdiction over the house. And usually the property must be located in the same country as the court for it to have in rem jurisdiction. Move on to the next part. Khoa.
So the next part is jurisdiction over to subject matter. Subject matter jurisdiction refers to the limitation authority on the types of cases that a court can hear and decide a specific type of dispute. In both federal and state court system, there are 2 types of jurisdiction: courts, a court of general jurisdiction, involving a broad array of issues. Typically, this court can hear civil cases involving the same types of issues. That cause of limited jurisdiction here, although the amounts of damage will be higher and may reach millions. This court also hear the most serious form of criminal matter, including death penalty cases. Court of limited jurisdiction, tòa án có thẩm quyền hạn chế. It can only hear and decide certain limited legal issues. Typically, this court hears certain types of minor civil and criminal cases, such as traffic tickets or set bonds for criminal defendants. Đặc biệt bảo lãnh. So, subject matter jurisdiction can be limited by any of 4 flows. Second, the sum of controversy. Third, whether the cases involve a felony, that is a serious type of crime, or a misdemeanor, a less serious type of crime. And the fourth is whether the proceeding is a trial, tố tụng, or an appeal, kháng cáo. So next is the original and appellate jurisdiction. Next slide, please. So the court of original jurisdictions are those in which the cases is heard and decided for the first time. Courts of appellate jurisdiction have the power to review a prior decision in the same case made by both limited and general jurisdiction courts. So next part, I would like to invite Thong.
Yes, this next part is jurisdiction of the federal court. A federal court has a system cover the entire nation, and there are two main types of subject matter jurisdiction here. First is federal question. Federal courts will hear cases that involve issues touching on the Constitution or other federal laws. For example, a rent conflict, usually not a federal question. However, if a lessee declares that the owner is violating the Fair Housing Act on racial discrimination, it will raise a federal question. Second is diversity of citizenship. They must have different or diverse state citizenship, and the dollar amount in dispute exists $75,000. For example, the federal court will not have jurisdiction because citizens of Georgia is on both sides of the lawsuit. Next. Exclusive versus concurrent jurisdiction. Exclusive jurisdiction is a specific court has power to hear a particular case, while concurrent jurisdiction is two or more courts. As for example, if a crime that comes under the jurisdiction of a state court is committed on a federal common property, both state and federal courts have concurrent jurisdiction. Next slide, please. And here is exclusive concurrent jurisdiction for you to easily understand it. Next. And this is some factors. Next, please. Jurisdiction in cyberspace, because the internet does not have physical boundary. So they need to have another way to determine like sliding scale standard in the US. It's based on three types of internet business contexts used to determine when the exercise of jurisdiction over an out-of-state defendant is based on passive website, some interaction, substantial business interaction. Next. This is the international jurisdiction issue. Some foreign courts are developing similar standards. So business firms have to comply with laws in any jurisdiction in which they target customer. And this situation is complicated by the fact that many countries have different laws and very different from US laws. And this is the concept summary of jurisdiction. Thank you.
So moving to my part is about venue. So the first is definition. You can say venues is concerned with the most appropriate location for a trial. But next slide, please. But to be more specific, it must next slide, please. It must located in geographic neighborhood where the incident occurred or where the party resides. Venue in a civil case typically is where the defendant resides or does business, or whereas venue in a criminal case normally is where the crime occurred. And the next one is standing to suit. In Vietnamese, we have the kết khởi kiện. Next slide, please. Standing here, you can understand that if the party that filed the action in court has a legally protected interest at stake in the litigation, and it can be done on behalf of other person. For example, children or mentally incompetent person can have another person to standing for them. Yeah, next. Standing to suit can be divided into three parts, which means the first one is harm. That means the person who bring the lawsuit to the court must have suffered harm. They must face imminent harm, and it's rather be real. If it is hypothetical, it will not be accepted. And the second one is causation. That means it must have causal connection. And the last one is remedy. That means a favorable judge decision will remedy the injury. That is all of my part. Next one is my friend Wang.
Okay, so this is a part about the state and the federal court system. Next slide. Okay, I'll make it simple because this is basically the system. There's a Supreme Court, and under it, inferior to it is there's a state court system, which consists of a lot of state court units, and also there's a federal court system, and these two systems is independent of each other. Okay, so here is the state court system and how it works. First, there's a trial court, which can be conducted in either general jurisdiction or limited jurisdiction, and this is mainly to conduct trials and testimonials. Secondly, the appellate court, every state has one. That's the first thing, and also it is for reviewing the cases and hear arguments. And the only question that will be dealt here is the question of law. Moving on to the highest state court, it has the final say in the state's law, and only when the federal law is involved can the United States Supreme Court interfere. If not, then the highest state court has the final say in any cases inside the state. Next slide. Three-tier model. The first tier, which is U.S. District Court, is the equivalent of trial court of general jurisdiction, and every state has at least one U.S. District Court too. Secondly is the U.S. Court of Appeal, and there are 13 of them. Each possesses a certain place in a circuit, and so they will hear appeals from district court within their circuit, and the final decision is made by them in most cases. And finally is the U.S. Supreme Court, which is the highest level and made the final decision in federal law. There are usually 9 justices in the U.S. Supreme Court, and to issue a case to this court, you will need a writ of certiorari to submit. So that's all from my part. Moving to next.
So next, I will talk about the alternative dispute resolution, or you can call it ADR. Next. So in this method, the parties sit them down together and try to resolve a dispute through a formal hearing before a panel of experts, and the great advantage of ADR is its flexibility. Normally, the parties can control and decide what procedure will be used. And next, I will introduce to you some basic forms of ADR. So the first one is negotiation. So this is a process in which the parties attempt to settle their dispute informally with or without the attorney to represent them, and normally they can negotiate voluntarily before they proceed to trial. Next. So in the mediation, a neutral third party acts as a mediator and works with both sides in the dispute. They will emphasize their points of agreement and help them to evaluate their option. And finally, next is the arbitration. So in the arbitration, the parties present their argument and evidence before an arbitrator at a formal hearing. The arbitrator hears a dispute and imposes a resolution on the parties. They may be either binding or non-binding. So this is the end of my part. We move to the next part, the international dispute resolution.
So now you see me again, teacher. I will present the last part. The last part is international dispute resolution. Okay, next slide, please. So what will protect you when you engage in international business transaction? The God? I think no. Your faith? I think no. And your clauses. Yes, I think this will protect you. We will need clauses or regulation or rule to protect ourselves in the event that a party with whom we are dealing in another country breaches an agreement. Next slide, please. So often, party to international transactions include forum selection and choice of law clauses and arbitration clauses to protect themselves. Okay, next slide, please. Next. Next. Okay, I will take a real case example for you. The real case two-century lawsuit, millionaire Trịnh Vĩnh Bình versus Vietnamese government. So Mr. Trịnh Vĩnh Bình is a Dutch billionaire, and actually he was born in Vietnam. And in more than 30 years ago, he came back to Vietnam to invest in business and land. After about 10 years, he was arrested and put into the jail by Vietnamese government for violating Vietnamese regulation of land protection and management, as well as giving privacy. However, he claimed that Vietnamese government arrested him without cause and he has launched a lawsuit. So he's the reason to sue Vietnamese from Mr. Trịnh Vĩnh Bình were he sued the first time because of property claims, including personal compensation, that is, lock him up. And Mr. Bình continued to sue the Vietnamese government for the second time on the ground that the Vietnamese government did not comply with the commitment to pay the money and his property back in the previous out of court agreement. And as a result, International Court of Arbitration is the board of International Chamber of Commerce declared that Mr. Trịnh Vĩnh Bình won a lawsuit against the Vietnamese government. Accordingly, the Vietnamese government was forced to compensate the Vietnamese Dutch millionaire a total of 37,581,596 dollars in damage and nearly 7.9 million in legal fees. So that is the end of my group presentation. Thank you for listening.